Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. In my previous two videos, I had dealt with a very important topic under copyright law, that is fair dealing and moral rights of the author and of the copyrighted work. In this video, I will be dealing with ownership and authorship of a copyrighted work under the copyright law in India. Ownership in copyright is different from ownership in the physical material in which work is fixed. A person who owns a book may not be the owner of the copyright therein. As a rule, author is the first owner of the copyright in a work. However, the copyright laws provide certain exceptions to this rule which will be enumerated in the later part of the video. Now, to illustrate this point, if a photograph or a painting or a portrait has been made at the instance of any person for a valuable consideration, then such a person is the first owner of the copyright in this case. Now, who is an author? An author is basically a person who in fact writes, draws, compiles or composes the work in issue, although the idea may have been suggested by a different person. The rationale behind this is that the originator behind the idea is not the copyright owner of the work unless he is also the creator of the work. Now, there are certain exceptions to the general rule that the author is the first owner, that is, when the author is an employee and the work is created under the course of such an employment, or the work is a cinematographic film or sound recording, then the copyright in the work vests with the employer. An author may create a work independently, or he may create a work under contract of service or contract for service. The two phrases to be noted here is contract of service and contract for service. Where a man employs another to do work for him under his direct control and supervision, which includes what to be done and how it is to be done, then it is a contract of service. If, on the other hand, a man employs another person to do certain work but leaves it to the discretion of the other person, the manner in which it is to be performed to result in desired product, then it is a contract for service. Another exception in which the author is not the absolute owner of the work is joint authorship. A work of joint authorship means a work produced by the collaboration of two or more authors in which the contribution of one author is not distinct from the contribution of the other author or authors. Copyright also subsists in such works of joint ownership. To constitute joint ownership, it is necessary that there should be a common design and cooperation in carrying out such a design. A person who just suggests the idea or the subject matter of the work cannot be considered as a joint author. Section 17 of the copyright law enumerates the statutory exceptions to the author as the first owner. So, according to section 17, the author of the work is the first owner of copyright therein. This is subject to the following statutory exceptions. Firstly, literary, dramatic and artistic work. Where the work is made by the author in the course of his employment by the proprietor of a newspaper, magazine or similar periodical under a contract of service or apprenticeship for the purpose of publication in a newspaper, magazine or any such periodical, etc., the said proprietor, in the absence of any agreement to the contrary, will be the first owner of the copyright in the work so far as it relates to the publication of the work in the newspaper, etc., or to the reproduction of the work for the purpose of its being so published. But in all other aspects, the author will be the first owner of the copyright. Secondly, in case of photograph, painting, portrait, engraving or cinematographic film, where a photograph is taken or a painting or a portrait is drawn or an engraving or cinematographic film is made for a valuable consideration at the instance of any such person, in the absence of any agreement to the contrary, will be the first owner of the copyright therein. However, a person Does any of the above in the course of employment by the proprietor of a newspaper or magazine or similar periodical under a contract of service or apprenticeship for the purpose of publication in a newspaper, magazine, or any such periodical, the said proprietor, in the absence of any agreement to the contrary, will be the first owner of the copyright. Thirdly, work made in the course of employment. In the case of any work made in the course of author's employment under a contract of service or apprenticeship, the employer, not being proprietor of a newspaper, magazine, or similar periodical, in the absence of any agreement to the contrary, is the first owner of the copyright. Fourthly, lectures delivered in public. Where a person has delivered any address or speech in public, that person will be the first owner of the copyright therein. If the speech is delivered on behalf of some other person, such other owner will be the first owner of the copyright. This is so even if the person who delivers the speech is employed by any other person who arranges such address or speech or on whose behalf or premises it is delivered. Fifthly, government work. In the case of government work, the government, in the absence of any agreement to the contrary, will be the first owner of the copyright. Fifthly, work made on behalf of a public undertaking. In the case of work made or first published or under the direction or control of any public undertaking, such public undertaking will, in the absence of any agreement to the contrary, will be the first owner of the copyright therein. Lastly, works of certain international organizations. In such cases, the international organizations concerned will be the first owner of the copyright. Thank you so much for watching the video. Please subscribe to the channel for further and daily updates.